Trials of Karen Reed have become one of the most watched legal dramas in recent memory, centered around the tragic death of Boston police officer John O'Keefe. On a snowy January night in 2022, O'Keefe was found unresponsive in the snow outside a home in Canton, Massachusetts. Prosecutors allege that Reed, his girlfriend, struck him with her SUV in a fit of rage after a night of drinking and left him to die. The case quickly escalated beyond a typical vehicular homicide. Reed's defense claims she's being framed, and then O'Keefe was beaten inside the house by others, suggesting a conspiracy and cover-up involving law enforcement. The courtroom has seen explosive testimony, conflicting expert opinions, and divided the public, many of whom believe Reed is a scapegoat. Her first trial ended in a mistrial, setting the stage for a second round filled with even more scrutiny. As the retrial unfolds, questions linger. Was it a tragic accident fueled by alcohol and emotion, or something far darker hidden behind a badge?
Live from downtown Dedham, Massachusetts, the site of the Karen Reed retrial, this is Closing Arguments. And now here is your host, Vinnie Politan.
Welcome. We are live in Dedham, Massachusetts, just down the street from the courthouse where the retrial of the century wraps up another week, and we're getting closer and closer to those jury deliberations. The first time around, obviously, the jury could not reach consensus, hung jury, so we have this retrial. It's been an amazing week up here in Dedham. Amazing crowds here for our shows. We've got another great crowd here tonight. They are locked, they are loaded, they are full of opinions. We'll get to them a little bit later in the hour. Also a big week inside the courtroom. A lot of interesting issues came up, but today was DNA Day. Now this case and this trial is not your classic DNA case. I think the classic is more like what's happening out in Idaho in that case, where DNA is left at the crime scene and it's up to investigators to try to match that DNA to a suspect. That's the classic DNA. Here it's a little bit different. It's a matter of, okay, there's DNA that we found, but what exactly does it mean? What story does it tell? And what does it prove, if anything? I said it was DNA Day inside the courtroom, so let's bring in Court TV crime and justice correspondent Matt Johnson, who was in there for all of it, and let's talk about that DNA. Matt, this is not, you know, our classic DNA case. This is a little bit different, a little bit, actually a lot different. So the first thing I want to talk about is the DNA that was found on John O'Keefe's clothing, because I think that's significant.
And it's a good thing that, Vinny, you know, when I was in there this week and watching today, they take a lot of notes. Yeah. These jurors love to take notes with experts, and today, their hands were cramping up. Let me tell you, because there's a lot to go over. All right, let's do this. So, John O'Keefe's clothing, several samples were containing several contributors, and beginning with his jeans. So let's put those on your screen. Stain A. Upper right leg of jeans had 3 contributors, that's John O'Keefe and 2 unknown individuals. Stain B had upper right leg of his jeans, 3 contributors, John O'Keefe and 2 unknown individuals. Stain 3, upper right leg, 2 contributors, John O'Keefe and 1 unknown individual. Stain D, upper right leg, 3 contributors, John O'Keefe and 2 unknown individuals. Stain E, upper right leg, the jeans, 2 contributors, John O'Keefe and somebody else. And then there was unstained areas of his jeans, 4 contributors, John O'Keefe and 3 unknown individuals.
Okay, that's a lot. That's a lot of unknowns.
Right.
And unknowns can be known if you have samples to compare them to. And I think the defense tried to get to that point today, didn't they? Trying to point out, well, did you have any of the DNA from certain people that have been implicated by the defense? And they didn't have that to compare to, did they?
as they're trying to bring in their third-party defense, and Canoni is only allowing that with evidence for Brian Higgins and Brian Albert, but they did not have that and did not compare.
Okay, now there's more clothing, right?
Right.
You got the sweatshirt.
The gray sweatshirt, so that's the outer layer. So let's take a look at this. Stain L, the back bottom right area, the sleeve of the shirt, 2 contributors, John O'Keefe and 1 unknown person. And then there was a sample from an unstained area of the hoodie, the sweatshirt, 2 contributors, John O'Keefe and another person.
Okay. So you think about DNA, how does it can get transferred very easily, right? If I hugged you right now, Matt Johnson, you
Please
might.
don't.
I know, I'm not going to. I'm not going to invade your space. But if I did, I mean, perhaps some of the DNA from my fingertips could end up
touch
DNA.
Yeah.
And DNA has gotten so much better, the testing and the swabbing.
And that's Coburger that you're talking about. Also, that's a great example, is the touch DNA.
Absolutely. So how about the sneaker, or as you would say in California, tennis shoe, right?
Yeah.
Okay. What was found there?
Or, pickleball shoe.
Pickleball shoe.
So the sneaker is stain D, instep, right sneaker, 5 contributors, and this was too many to do any testing or comparison. And this is interesting also because that was the shoe that was missing that was found at 34 Fairview.
Okay, not the one that he's wearing at the hospital, but the one that was, according to prosecutors, buried in the snow.
Near the curb.
Near the curb.
Right.
Interesting,
Yeah.
interesting. Okay, let's talk about DNA. So the unknown DNA, obviously that's something that the defense will likely pounce on, but there was also DNA associated with the taillight today.
Yeah, this was big testimony. It's something that we expected. We heard about this last year, and prosecutors and both the defense were trying to talk about that and weave it into their case, right? So we have the jurors listening to this expert, the DNA expert, about the taillight, and he's really talking about the touch DNA, and here's what was said in court. Take a listen.
Turning your attention back to item 3-1.1, that's the sample from the passenger side taillight of the defendant's vehicle, correct?
Correct.
Okay. And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side taillight, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion, sir?
The DNA profile from this item is 510 non-alien times more likely to have originated from John O'Keefe.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022?
Okay, so that's Andre Porto. Again, he is the DNA analyst in this case, talking about the touch DNA that was John O'Keefe. But again, yesterday, remember, there was an expert that took the stand that was talking about the collection of with swabs, and it was on the outer part of the tail light, not on the inner part or the cracked area. So that's interesting to point. And then the defense, of course, was saying, in their cross today, he's the boyfriend.
Right.
Of course, his DNA is going to be all over this car.
I think both sides have these double-edged arguments, right?
Right.
The unknown DNA could be just someone, I'm not going to hug you, but someone hugging John O'Keefe at the bar that night, right?
Right.
There were other people, or bumped into someone. Or
with the clothing, yeah.
Exactly, with the clothing. And then, by the same token, obviously, he could have been walking by Karen Reed's vehicle at any time. Over the course of time. So let's focus in on the taillight now, because they put it back together today, didn't they?
Right. So we had another witness on the stand, and this is another person that testified last year. So her name was Ashley Valier. She goes by Ash, and her title is actually Physical Match Analyst. That's a real thing. And she works at the crime lab, and she basically puts puzzle pieces together for a living, which is pretty cool. And this was part of her testimony.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct, or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from One Meadows Ave in Canton?
No.
Were you ever told about a collision at One Meadows Ave in Canton?
Okay, so she puts all of the puzzle pieces together, and there's, look, right there, in the middle of your screen, they're still missing a piece. She's pointing out right there, and the defense really pounced on that like we saw last year, because they were also pointing out that this is the one missing piece that Karen Reed was saying to Jen McCabe and others that was missing and cracked when she
and that, again,
mentioned that.
There's this
at
case,
Meadows.
nothing is 100% clear in this case ever. So they put the taillight together, but there's a piece that is missing. Karen Reed says that's the piece that was missing when she backed into John O'Keefe's car.
Right, because for the defense, it's only that one piece.
Right, so they're not arguing was the taillight cracked or not cracked. It's how cracked was it becomes the issue.
Right.
Interesting. Now, every day these lawyers, they have something to say without the jury there. Again today, but this is a really big one.
This was really big, and it was an argument that spanned over 2 days. This is how yesterday ended. We kind of talked about it a lot. We expected a ruling at the beginning of the day, and it has to do with discovery. And the defense was claiming a Rule 14 violation of reports being turned over by the brand new experts that are yet to testify on the stand. So this was heated arguments. It was Alessi and Brennan squaring off today, talking about what's going to be called the aperture experts and their new report, their data about the internal clock in Karen Reed's SUV compared to John O'Keefe's iPhone. Here is the judge's ruling on that.
The defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that.
So right there at the defense table, I was looking over at Karen Reed. She was shaking her head. She was looking at her attorneys. They were asking, Alessi was asking for at least a 4-day continuance.
Didn't get it.
Didn't get that. Judge Cannoni said no delays in this case. And they also said the proper remedy would be to not allow those reports to be in court at all or to testify to. Outside the courthouse earlier today, I tried to get a statement from Karen Reed. Take a listen.
Guys, we're coming close to the end. There'll be no comment from Karen today.
Okay, thank you.
All right, and then that's an indication right there of just how far we are in this retrial, because they're not talking, and they did that last year as they entered their case in chief, and also when we were in verdict watch. So we may have the state rest next week or the day after Memorial holiday.
Wow. And if Karen Reed is not giving a statement to Matt Johnson, she's not giving statements because you've been getting information day in and day out.
She's getting ready to take the stand.
Oh, wow. All right. Matt Johnson, folks, thank you so much. All right. Let's bring in our trial insiders joining us here in studio. Who do we have? Joseph Krowski Jr. He is a legend in these parts. Look at that. They're clapping for you now. They're clapping for you, Joe. Margaret McLean, former prosecutor and host of It's a Crime with Margaret McLean. Peter Ellikin, who I've known longer than everyone on this stage. He's been on Court TV longer than I have.
I come with the building.
There he is. Peter Ellikin, great criminal defense attorney. And Nick Rocco, who has done a lot to support Karen Reed. All right. Are you mad they clapped louder for Nick Rocco than you?
I expected that,
You expected, you did, absolutely. Okay, I want to focus in on the DNA. I want to focus in on the DNA, all this unknown DNA. As a prosecutor, I don't like it. I'm a former prosecutor. What is the explanation for all this unknown DNA on John O'Keefe's clothing?
Well, first of all, Vinnie, I just have to say it's DNA Day, and you forgot a major piece of this whole thing. How did they start this out? As a lawyer and a woman, they started this whole DNA Day out with a clip of Karen Reed pulling glass out of John O'Keefe's face. Right, or her talking about her talking about it. And as a lawyer, first of all, I'm really surprised that her attorneys allowed her to go on television and talk about that, because that plays...
They always say that. We want everyone coming on television.
Oh, well, that's true, but it plays right into the prosecution's case that she was, that John O'Keefe was holding a cocktail glass when she hit him with the SUV. Now, as a woman, I will also say that, if I had a boyfriend who I loved very much, and I'm on television talking about picking glass out of his face. I'm sorry, I'd break down and cry. And I feel that a lot of women have come up to me and said, you know, how come she's not more sympathetic? Like when you're talking about when she sees clips of the crime scene or the autopsy, it's okay to cry, it's okay to show emotion, but I sometimes feel like she comes across as a little cold. And I mean, Nick, what do you think about that?
Well, I just want to point out, though, I did ask about the DNA, so we haven't gotten the explanation for that.
So you have unknown DNA all over John O'Keefe's clothes. It could be from someone hugging him in the bar. It could be from someone bumping into him. It could be from someone carrying him outside of 34 Fairview Road. But guess what? The investigators did not do their job. They held on to his clothes for 6 weeks and did not hand them over to the crime lab. And who knows what happened? You know, we don't know whose hands were on those clothes. And if they did a proper investigation, they could have, and the defense has tried to get the DNA of the people inside those houses to rule them out. But the police did not do their job. And that's why now we have more reasonable doubt to add to the pile.
Right, now, you know, normally DNA can really nail and put to rest a case. This is not one of them. And even the fact that you talk about what around the car, I mean, that was a boyfriend. He was in and out of that car all the time. So the fact that he would have DNA or hair or fingerprints, it probably wouldn't make any, I mean, it's kind of expected. And this is very different from other cases where, for example, if it was a stranger, if let's say I was driving my car, I hit somebody, then I drove off, and when they arrested me, I said, not my car, I didn't do it. And then they found his DNA on it. It would be like, case over, you are nailed. Not even a reason for a trial. So DNA can often put a case to bed. In this case, though, it's just kind of a mishmash, particularly with, you know, all the different kinds of DNA that they didn't compare it to all over the place.
Let's not discount the DNA altogether. They swabbed, and they had a buccal swab from John O'Keefe. They matched it to the area of the taillight where they believe he was struck. They had exclusion buccal swabs from Proctor and Tully, eliminating them as a potential source of DNA, thereby eliminating the issue of whether or not it was planted. The hair on the car, I believe they are going to use Bodie, which is really the gold standard for DNA testing, is going to come back to John. As it relates to DNA, DNA is so small and so sensitive now, there are literally 10,000 strands on the head of a pin. It's not only transferred primarily, but it can also be transferred through secondary and tertiary transfer. Everyone in this building, in this room right now, if you tested their clothing, it would have 5, 6, 7 different sources, contributors of DNA. And all of that clothing was handled after he had life-saving measures taken. It was handled by EMTs and first responders and hospital staff.
So why not run the test to eliminate or figure out whose it is?
Because if you listen to all of the testimony, a lot of it is not suitable for comparison. There are standards, there's criteria. You have to have, no, let me finish. I've been litigating DNA issues for 25 years. They won't even test it.
DNA 25 years ago?
They did. If it's not suitable for comparison, because it's not reliable. It has to have 19 areas of agreement. It didn't have that, so they didn't do it. But on what ruled the day is John O'Keefe's DNA is on that taillight to the exclusion of Proctor and Tully. You would expect to find 4 or 5 contributors on someone's clothing that was in a bar.
Was on the housing. All the pieces that were in the yard, there wasn't blood, there was no DNA on those pieces. It was only on the housing that was still attached to her vehicle. And so you're telling me that, oh, he just, you know, potentially just swiped across that one part. If he got hit, why is the DNA not on the rest of the taillight pieces?
And you're right, it could be anybody's DNA. He could have been hugging people in the bar or whatever, but the fact that the jury's going to listen to that and say, well, you know, it could be a lot of friends or people in the bar. It could be the people were particularly his shoe with 5 different DNAs on it. It could have been people who were assaulting him. You don't know at the end. And so once again, I keep bringing up this phrase, reasonable doubt. You're not nailing.
But you can't say reasonable doubt with people assaulted him. We still haven't heard a single witness. That's just innuendo. These are building blocks. The case doesn't rise and fall on one simple piece of evidence. The fact that his DNA, his human hair is on that car and his DNA is on the taillight is significant. One more part to that. Of course it is. Of course it is. It's relevant. Hold on. One more part of that.
That's absurd.
The defense, it's absurd that where he got hit and where the car was damaged has his DNA. You can explain it away, but it's relevant. One important thing, the defense had to backtrack today and concede Proctor was not at the autopsy. That was not his photo. How would Michael Proctor have gotten a human hair from John O'Keefe to plant it on that car?
Human hair was there. That was his girlfriend's car. So yeah, his hair could be anywhere in that car.
All right,
they're fired up. Our audience is fired up. When we come back, is the prosecution changing their timeline?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Coming up next, only on Court TV.
Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was framed!
We know who did it.
The Karen Reed Murder Retrial. Live coverage weekday mornings, 8, 7 Central on Court TV.
The timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the time.
This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses.
Welcome back. We are live in Dedham. The prosecution defense, they can't agree about anything. So the defense is accusing the prosecution of changing their timeline, changing the time that they allege Karen Reed struck and killed John O'Keefe. The prosecution is saying, we never changed it. So I want you to take a listen, because timeline is really important. And I think it's much more important in this second trial than it was in the first trial. Here's Hank Brennan, the special prosecutor, explaining his timeline, and I believe telling us the time that the prosecution alleges John O'Keefe was struck by Karen Reed's car.
We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock and an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts on both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream. and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault.
My job, I get paid to watch these cases, listen to the attorneys, try to understand it, provide some analysis, and explain it to viewers every night. Jurors just come in, they get a notice and they come in and they have to try to understand it. I didn't understand all of that. There's some time shifting going on here. What exactly does that mean? To me, it's still not clear. I want you to take a look at some of the timeline evidence that has come in already in this case, and a lot of it came in through that expert witness that the prosecution brought in with the English accent, Ian Whiffen. Take a look. During the cross-examination of Ian Whiffen, 12:31:38, according to the Aperture report, and this was in the cross-examination, that was the time of the triggering event, the collision. But now we're hearing that the Lexus infotainment system, which is mentioned in this hearing, that the time of the collision is 12:31 and 43 seconds. Okay, what we also learned was that at 12:31 and 56 seconds after the collision time is the start of a health event of 36 steps by John O'Keefe. So after the collision, it starts recording him moving 36 steps. 12:32:09, John O'Keefe's phone is locked for the last time. Again, this is all after the collision times that we're hearing. Then at 12:32:16 was the end of the health event, the end of the steps. So I was thinking he got hit maybe at 12:32:16, maybe at 12:31:38, but now we're hearing 12:31:43. Still doesn't make sense to me. Then on the timeline, there were a series of calls that Karen Reed makes to John. Obviously, they're not answered. There's also a voicemail in there as well. Those continue in the timeline. There's a message from Jennifer McCabe at 12:40, which is unread. There's another one from Jennifer McCabe, 12:42, that's unread. 12:45 is when prior testimony of Jennifer McCabe says that Karen's SUV was parked outside 34 Fairview. Last year, Adam Lally in his opening statement told us that 12:45 was the time of the collision. 12:45 and 53 seconds, there was a message from Jennifer McCabe saying hello, which again was not read. And that's from the testimony of Ian Whiffen, but the testimony of Jennifer McCabe was that I recall that she saw the SUV and knew the time because she was texting. So none of this makes sense to me. That's why I have help tonight. We have our great guest with us. Make it make sense to me. I'm gonna ask you first, Margaret. What time was John O'Keefe struck by Karen Reed, according to prosecutors?
12:31.
12:31 in how many seconds?
Oh, God.
38 seconds
38
according to
seconds.
Aperture, or 43 according to the infotainment system?
So that's the problem I have. We do have an extra report here, and I think Judge Cannoni should have held a voir dire because it just doesn't seem fair to the defense in this particular case. I mean,
right,
it's
because this
very
report
confusing.
either changes things or the defense is completely misreading it.
It changes nothing, and if you bear...
What time was he struck? Was it 12:31, 43?
You said you didn't understand it. I'm going to explain it to you.
Yes, Professor Craig.
And if you listen to this objectively, you will have no doubt that the only issue is whether or not there is a viable murder charge. There was new technology after Trial 1 to Trial 2. You heard the prosecutor explain the three-point turn. That was 7 minutes prior to arriving at 34 Fairview. They now have infotainment information from the Lexus, which gives them time and place of the three-point turn. They were able to match that up with the ways of the phone and come to an absolute, unassailable conclusion that the phone was 21 to 29 seconds slower than the infotainment on the car. That's the variant. Now get to 34 Fairview. The backing up event of the Lexus is 21:33. We know from the Lexus data it backs up for at least 10 seconds.
31-33 or 21-33?
12:31:33.
Okay, seconds matter.
Seconds matter. We know it backed up for at least 10, maybe 20 seconds. If you do the variant and minus the 21 to 29 seconds, because they say John O'Keefe's phone stopped moving at 12:32:16. You subtract that 21 to 29 seconds, it is bone-chilling. Her car is backing up when his phone doesn't move.
It took her 20 seconds to back up 62 feet at 24 miles per hour?
No, I'm saying the data shows it's at least a 10-second backup.
Here's your problem, though.
It's not a problem. It's unassailable. It's science.
The jury is going to be listening to this. And although Judge Cannone sided with the prosecution this time, she gave the defense wide latitude to question this. They're going to hear that somebody's changing their story at the very last minute because he heard a prior witness. Let me finish.
Okay.
A prior witness testify.
You to be right.
And they're going to say he's supposed to be sequestered, not listen to what the prior witness said. And the prior witness, their stories don't gel. So now he suddenly comes up with a new thing to match it.
No.
And they're going to hear this story back and forth, and who are they going to side? Are they going to believe? Which side are they going to believe with? You're not supposed to bring in what we refer to as a Perry Mason moment, like the old days. The old Perry Mason show in the 1950s.
Here's
in the
what
1950s, the Perry Mason show, he was always going to lose.
I can't even tell if you're watching the trial at this point. Here's what happened.
And then with the Perry
Mason
show, he was always going to lose in the last 5 seconds. So a surprise witness with bars to the doors.
Perry Mason.
You can't do that.
Bob Alessi is a very intelligent guy.
I have a comment, though. Here's an issue that I have with this. We do have a new report, and what I'm worried about is there was no voir dire, and if Karen Reed is convicted, it's going to go up on appeal. Then we're going to have problems.
Bob Alessi is a very bright guy, but very bright. He has a ton of integrity. This was an uh-oh moment for him. What happened, and he now knows it, I'm sure he knows it, is they had an expert. And look, this was a lot of their choosing using ARCA. They had an expert that did his own analysis. And when he found the variant, he inverted it. He got it wrong. And I know Bob is looking at it and knows he got it wrong.
So you say he shifted the time the wrong direction?
The wrong direction. So all the Commonwealth did was forward the new report to their expert to have it peer-reviewed. He caught it right away, send it an amended report.
Could have done that long ago.
No, they just got that report. They just got that report.
When we come back,
it's bad
time
news.
to hear
bad
from
news
our
for the
studio
audience.
So John's laying there on his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
That was the clip of Karen Reed that Margaret McLean was talking about. We've got a live studio audience. They've got questions. They've got comments. They may even have some theories. Let's go to Court TV crime and justice correspondent Matt Johnson, who is with our audience tonight.
And they are revved up and ready to talk true crime, aren't we ready?
True crime. We're ready.
True crime. Okay, so Elizabeth has traveled here from Washington State. What is your question for the panel?
I'm going to go back a little ways. So who here has a go-to person? Like, is there someone that you text? Is there someone here? I want you to kind of think about that, because what I've thought about is there's not one person on the planet that received a text from their go-to people, not from the paramedic, not from the witnesses, not from anyone, that says, I just heard a confession. I mean, if we hear something like that, aren't we apt to text our partner, our friend, Jennifer Catone? I gotta mention it. What are your thoughts on that?
Yeah, I've always thought, like, for example, one example, Jen McCabe. Somebody confesses to a homicide in front of her, and she's furious at that person, but she talks to the grand jury weeks later, etc. And at some point, months and months down the line, oh yeah, confess to the homicide in front of me. I just didn't happen to bring it up. And we have loads of examples in this case, the different
at a minimum, a spouse or a boyfriend or girlfriend.
The only text we saw was telling the guy didn't come in the house.
Yeah.
That's the only text we saw.
All right, panel, we have Marnie joining us. So where are you from? And you watched trial number 1, right? You're really into this. What's your question for the panel?
My question is, how does this jury differ from the last jury? And also, how will it affect the decision-making for this jury?
Well, we could both answer that, right? Because we saw the jury. You were saying that they're younger, Vinnie.
To me, I just feel like this is a really young jury. And I feel like that is, I know nothing about them, but I just feel, generally speaking, that young people are much more skeptical of people in charge, of grown-ups, of the government, of police. And I think that leans towards the defense. And like, I would say more than half this jury is young for a jury.
And they're very stoic. I'm seeing less emotion from the jury this time around than last time. And then there was a moment today where the judge actually said, don't say anything under your breath. I'm not sure who she was talking about, but that was an interesting moment.
Yeah, it really was. I mean, I didn't hear anything when I was in there. No. You didn't hear anything anyway, but you don't just say that. I mean, the judge said that for a reason. Someone must have been saying something.
So, yeah, thank you for your question. All right, let me bring you down. This is Lisa. You watched trial number 1 as well, I'm presuming. What's your question for our panel and Vinnie?
My question's for actually Attorney McLean. Is that possible? Love your podcast.
Oh,
I listened to it, and I listened to it last year, and I remember you were thinking that the jury was going to come back with a not guilty verdict. Sorry, I'm nervous.
You're doing good. Doing better than me.
Why do you think they were hung instead of not guilty? And do you think that they're going to be hung up on the same things that they were hung up last year?
That's a great question. Well, first of all, I thought it was not guilty last year all day long and was surprised. So the jury was hung up on the manslaughter charge, and one of the jurors came out, I believe it was 9-3, 9 in favor of conviction, and they were all caught up on the manner of death, and that's of course what the medical examiner was talking about yesterday. So they saw John O'Keefe, they saw these injuries, but they just couldn't put it together as to what exactly happened to John O'Keefe.
All right, we have another question from Samantha. Thanks for being here. What's your question, and how does that tie into the case?
I just kind of want to bring it back to Trooper Proctor, or former Trooper
Fired Trooper Proctor.
Right, fired. And I understand why the Commonwealth would not want to call him or would feel like they would have to call him. And whether they do or not, it's kind of sounds like the defense is not going to call him. And in what world is that a good decision? It seems like the defense should call him. It could only benefit the defense. Is there any way that it would not benefit them to call him?
And to that, when I asked Karen Reed, because everyone's under a gag order, she said TBD. So we still don't know if even the defense will call.
So strategically, if you've noticed, they're using every conceivable exception to the rules of hearsay to try to inject his name into this case. I do agree with you right now, though. What are we left with as it relates to Proctor? 4 texts. I mean, there's some inflection and innuendo, but there's no concrete evidence of any misconduct or malfeasance. I do think they'd rather inject him this way rather than have to call him, because then you subject him to cross-examination from the prosecution.
I think it goes just beyond, though, his text. For example, that a body is found outside of the door of a house on the lawn, in a small lawn, and he doesn't even go in and review the place to look at it, and then he can say, gee, there's no evidence that there was anything that took place in the house. Those are the kinds of things, that kind of shoddy police work, again and again and again in this case, that really needs to be brought up. And if I was the defense attorney on this case, I would absolutely call him so we can go over that every little bit.
All right, we have Stacy. You've been in the audience before. Yes, I recognize you. You got the bling going on and your notes.
Yes.
Now, I've noticed that this is a full paragraph. You have your notes. She probably has one of those crime boards at her house with yarn.
Exactly.
Like my office. Anyways, thank you for being here. What's your question?
So it's not a question, it's a comment. First of all, I'm Team Attorney Krowski Jr. I want to give him all kind of dap and credit and everything.
The few, the proud, right?
You take on Mr. Rocco's comments and assertions, and I really like that because I'm Team Commonwealth. I believe she did it. If you were to walk in your kitchen and your dog has a bowl of something on the floor that was sitting on the counter, that you're the only one home, and you and the dog, and you come into a kitchen with all this mess everywhere, it's like common sense. It's nothing but facts. If the Commonwealth stick to the facts, they should be able to prove this. Fact number 1, broken tail light. Fact number 2, Officer O'Keefe laying on the ground, deceased. Fact number 3, I mean, I have so many.
Well, Stacey, let me ask the panel this right now. Vinnie and panel, like, the Commonwealth is being more surgical from an outside person just observing it.
Let's let Nick respond to this one real quick.
47 pieces that were not found in 4 inches of snow. And then I'm not sure what you were getting at with the dog and the kitchen being a mess, but...
I was trying to make an example of
the dog,
when things happen, you can deduce.
But the dog is gone.
But
They rehomed the dog.
It doesn't matter. The dog was there.
How do you know? Jen
We have run out of time.
No, I'm not talking
We have run out of time.
I'm not talking about
Big thank you to our great studio audience, Joseph Pesci Jr., Margaret McClain, Peter Ellikin, and Nick Rocco. When we come back, something else you need to know tonight.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central, only on Court TV.
Just look at that touch from Trinity Rodman.
Saturday night.
When she is on the field, she changes the game. Saturday night. Saturday night is our night.
The new Saturday Night Out is on ION all season long.
Time to reveal something else you need to know tonight. Let's take a look at the big board and see what's happening in the world of crime and justice. Trial day 5 in the Diddy sex trafficking case, and another day of cross-examination for his ex, Cassie. Court TV legal correspondent Kelly Craft is in New York City with the latest tonight.
Hi there, Vinnie. What a day here in court in New York City for the criminal trial of Sean Diddy Combs. Cassie Ventura, the prosecution's star witness, on the stand. Now, her testimony has concluded, but during times of her testimony today, she was breaking down in tears when she was talking about the $20 million settlement she received from Sean Combs. She also talked about a $10 million settlement that she will be receiving from the Intercontinental Hotel in California. This is from the release of that video in which Sean Combs is seen beating her inside that elevator lobby. Sean Combs listening closely as his ex-girlfriend, Cassie Ventura, was detailing how she felt forced to take part in sexual freak-offs, testifying that Combs would take her phone, passport, watch, and other possessions when he was angry with her. She did burst into tears when she talked about the freak-offs, saying she would give back the $20 million settlement if she would never have had to do the freak-offs. After the conclusion of Cassie Ventura's testimony, her attorney read a statement from Cassie in which she thanked those who have supported her. And her husband, Alex Fine, said in that statement, Sean Combs thought he could break Cassie, but he couldn't. And Vinnie, after that cross-examination of Cassie Ventura was finished, Sean Combs was seen hugging his defense counsel. Now, when court resumes on Monday morning, Dawn Richard, she will be back on the witness stand. On Friday, she was testifying about an incident in which she witnessed Sean Combs beating Cassie. Also, next week, we expect to hear from Cassie's mother, who will also be a prosecution witness. That's the latest from here in New York City. Vinnie, we'll send it back to you.
Kelly Craft in New York City with all the latest in the Diddy case, and we'll continue to monitor everything that's happening in that trial. What I need you to do right now, though, is take a look at your television screens because we have a missing child who needs your help tonight. Take a look. This is Rebecca Roxanne Nupp. She's been missing since May 14th out of Bethany, Missouri. She's just 17 years old. Now, she may still be in the local area, but she may also travel to other cities in Missouri, perhaps Iowa, and even Arkansas. So please take a look at her picture. You see her, pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or you can call the local authorities there in Harrison County in Missouri. Okay, don't go anywhere. We have another hour of live true crime. We're live in Dedham, Massachusetts, covering the Karen Read retrial. In the meantime, please don't forget to hug the kids.